Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss the concept of commencement of CIRP and the moratorium. So before discussing the today's concept, let us recap what we have discussed in the previous session. In the previous session also, we have discussed the concept of moratorium, where we have discussed the objectives behind the moratorium, why we are fixing the moratorium, and we have discussed the provisions of section 13 and section 14. Then we have discussed the purpose of moratorium. Then we have discussed that once the moratorium is announced, okay, so it is going to stay the proceedings, automatic stay of the proceedings. That means all the cases against the company will be stayed, and moratorium does not extend to the subsidiary company. So one question is that whether if moratorium is announced in favor of one corporate debtor, or if moratorium is announced in case of one corporate debtor, whether does it extends to the subsidiary company also. So we have learned that moratorium does not extend to subsidiary company. Whether moratorium prevent the proceedings which are for the benefit of the corporate debtor, we learn that moratorium does not prevent the proceedings which are for the benefit of the corporate debtor. That means if any proceedings are for the benefit of the corporate debtor, then such proceedings will continue even during the moratorium period. Next, whether section 138 proceedings against the promoter can continue even during the moratorium. So another question mark is that if you observe section 138 of the Negotiable Instruments Act, so which is speaking about whenever there is a dishonor of the check is there, okay, then that is check bounce cases, then the opposite person, that is the person who is entitled to receive the payment, who is having the check, he is having a right to file a case against the corporate debtor or any other person who gave the check, that is against the drawer. Okay, so the payee is having a right to file a case against the drawer. As already we know that there are three parties are there in case of check: drawer, drawee and payee. Payee is a person who is having the check. Drawer is a person who gave the check. Drawee is a person, it is always a banking institution who is liable to make the payment. Okay. So in case of check, if the drawer gives the check to payee, and if the payee submits, that is presented the check to the banking institution, and the check is dishonored because of non-availability of the funds, then in such cases the payee can file a case against the drawer. So this is a provision under section 138. So please remember, section 138 is considered to be criminal proceedings. Okay, so because it is considered to be an offense, and the person, that is the drawer, is liable for imprisonment also. Okay, under section 138, that with other sections followed by some other sections are there. Okay, so he is liable for imprisonment also. So it is considered to be criminal proceedings. Now the question mark is that whether this section 138 proceedings can continue against the promoter or not. Okay, so Supreme Court in the case of P. Mohan Raj versus Shah Brothers Ispat Private Limited. In this case, the Supreme Court held that the proceedings under section 138 can continue against the directors. Okay, because if the company is giving the check, okay, here in this case actually the drawer happens to be corporate debtor, that is the company. So if the company gives check to someone else, that is someone else is a payee. So payee can file a case against the drawer. So on behalf of the company, directors are the people who are liable actually. Okay, so if any proceedings are there against the company under section 138, then you are going to make both director as well as company as the opposite party. So that's why in this case, Supreme Court in the case of P. Mohan Raj versus Shah Brothers Ispat Private Limited, it was held that you can continue the proceedings against the director, but you cannot continue the proceedings against the company. Okay, so in section 138 case, both the parties will be there. Okay, director as well as company will be there. So the above judgment is once again reiterated by the Supreme Court. Okay, so in another case, Gimpex Private Limited versus Manoj Goyal. Okay, so even in another case, Nag Leathers Private Limited versus Dynamic Marketing Partnership. Okay, so the case of P. Mohan Raj versus Shah Brothers Ispat Private Limited. So where it was held that whether criminal proceedings, that is section 138 proceedings, can continue against the promoter during the moratorium period. the Supreme Court held that yes, you can continue. So the same thing is reiterated, that is reconfirmed by the Supreme Court in the case of Gimpex Private Limited versus Manoj Goyal, and in another case Nag Leathers Private Limited versus Dynamic Marketing Partnership. Okay, in both the cases Supreme Court supported the judgment or reiterated the judgment given under in the case of Mohan Raj case law. Okay, now, so whether moratorium is terminated, does the moratorium is terminated or nullify existing contracts of CD? So when the moratorium is implemented, whether the moratorium is going to terminate the nullify existing contract? No. Okay, the Calcutta High Court in the case of Gauri Shankar Jain versus Punjab National Bank, okay, the effect of moratorium is only temporary, please remember. Okay, so though we are imposing restriction on filing the cases or initiating any proceedings and transferring the property, it is only temporary in nature, because moratorium will be enforced from the date of initiation of CRP till maybe under section 31, maybe under section 33, when the court is passing the order, that is NCLT is passing the order. Okay, so that's why in the case of Gauri Shankar Jain versus Punjab National Bank, the Calcutta High Court held that the effect of moratorium is temporary in nature. Okay, the rights remains unaffected and intact. So we are not going to affect the rights, but such rights are suspended for a temporary period. Okay, so we are not totally cancelling the rights, we are only suspending the rights. Okay, so there is an impact of moratorium. Okay, so what is barred by the law of limitation is the right to remedy. Okay, not the right itself. Okay, so does not mean that when I am imposing the moratorium, I don't have the right. Okay, I am having the right, but now I cannot enforce my right against the company. Subsequently, once the moratorium is completed or there is lapsed, expired, then once again I can exercise the rights against the company. Okay, so my right is not violated, my right is not suspended, it is only right to remedy is suspended during the moratorium period. Okay, then moratorium and CRP do not improve or enhance the rights of CD, please remember. Okay, so here the rights of the financial creditor, operational creditor, they are suspended. Okay, but it does not mean that the rights of this CD is going to improve. Okay, so CRP process, okay, do not improve and enhance the rights of CD. Okay, corporate data rights are not going to be improved. Okay, so Supreme Court in the case of Embassy Property Developments Private Limited versus State of Karnataka. So in this case, the Supreme Court held that the moratorium should not be considered as a pinnacle to all that is wrong done by the corporate debtor and should not be considered as an escape route to evade any action by the statutory authority. So in this case, the Supreme Court clearly held that, please remember, okay, if any wrong is done by the corporate debtor shall be liable. Okay, so the moratorium, the concept of moratorium cannot be considered as an escape route. Okay, so to evade the action by the statutory authority. Why? Because statutory authority are always having right against the corporate debtor. Okay, so they can file a case against the corporate debtor at any point of time. But during the moratorium period, they cannot file. It does not mean that they don't have the right. Okay, the right is suspended for a temporary period. Okay, so moratorium can never be used as a escape route, to evade any action by the statutory authority. Okay, then statutory dues cannot recover in exercise of statutory powers by the statutory authority. So statutory dues are there, like taxes. We are supposed to pay the taxes. We are supposed to pay the municipal taxes, income tax, GST, etc., etc. So these are all various liabilities or various amounts which I am supposed to pay as a corporate debtor. I am supposed to pay. Okay, so here these rights cannot be recovered in exercise of the statutory powers by the statutory authority. Okay, so during the moratorium period, you cannot recover any money. Okay, so it was held in the case of Principal CAT, Commissioner of Income Tax versus Moneth Ispat and Energy Limited. So in this case, the Supreme Court held that the moratorium bars any coercive action taken by the statutory authority for the recovery of their dues. So once the moratorium is implemented or it came into enforcement, no statutory authority can coerce. Coerce means force. Okay, so they cannot coerce the corporate debtor to recover the money. Okay, so they cannot file any case, they cannot influence the corporate debtor to recover the money. Then in another case, Anju Agarwal versus Bombay Stock Exchange. NCLAD, National Appellate Tribunal, held that moratorium on outstanding amount payable to SEBI. So, if any amount is payable to SEBI, maybe SEBI has imposed some penalty. Maybe there is a violation of insider trading. Maybe some regulations were violated. So, in such cases, if the SEBI has imposed any penalty, okay, or if you are liable to pay some amount to the SEBI, then whether moratorium is applicable or whether moratorium is applied on the outstanding amount or not. Yes, moratorium on the outstanding amount payable to the SEBI is applied. Okay, so you are not liable to pay immediately. Okay, then whether attachment of property by statutory authority can continue, no, it cannot be continued. Okay, so suppose take the example as a statutory authority. Imagine the corporator fails to pay some amount, maybe some taxes. So as a statutory authority, you are having a right to attach the property of the corporate debtor, as if you are recovering the money. To recover the money, you are having the attachment, and subsequently you are going to give the notice. If the corporate debtor fails to make the payment, then you are going to sell the property. So that is the general process. Okay, so you are having powers to recover under the revenue legislations. Okay, so as a revenue collector, you can recover the property. That is the general process. But whether the attachment, if moratorium is affected, that is moratorium is attracted, then can you attach the property? So in the case of B. Parameshwara Udpa versus Assistant Provident Fund Commissioner. So in this case, NCLAT, National Appellate Tribunal, held that attachment of bank account of CD by the EPFO, Employees Provident Fund Officer, cannot be continued. Okay, so you cannot attach the property. Okay, so once the moratorium is enforced, even you cannot attach the property belongs to the corporate debtor. Okay, then attachment under the prevention of money laundering. Okay, so can you attach the property under the prevention of money laundering? Generally, whenever if any offenses happened, okay, under the prevention of money laundering act, money laundering is there, then in such cases the directorate generally under the prevention of PMLA act, that is prevention of money laundering act is called as PMLA act. Under PMLA act, the directorate general generally what they are going to do is they are going to attach the property. First they are going to attach the property, subsequently once the case is decided, they are going to sell the property. Okay, and please remember any thing that is happened under the prevention of money laundering act, generally it is considered to be an offense. Please remember. Okay, when someone is doing the money laundering, it is considered to be offense. Okay, so that's why it is criminal in nature. The offenses under the prevention of money laundering act, they are all criminal in nature. So when I am using the word offense, obviously it denotes the criminal in nature. Okay, now the question mark is that general principle is that criminal proceedings cannot be stalled. Okay, because of the moratorium, criminal proceedings cannot be stalled. Now the question mark is that under the money laundering act, whenever you are attaching the property, so it's a property. Okay, so whenever you are attaching the property of the CD, can they attach the property or not? So there is no unanimous opinion, contrary views are there. Okay, so different courts, they have given different opinion. Okay, let us look at that. In the case of Varsna Ispat Limited versus Deputy Director, Director General of Directorate of Enforcement, NCLAT, in this case NCLAT held that Section 14 is not applicable to the criminal proceedings, because the proceedings under the money laundering act, they are in the nature of criminal proceedings. So that's why Section 14 is not applicable. So this is a decision given by the NCLAT. But contrary to that, in the case of Rajiv Chakrabarti, Resolution Professional of EIEL versus Directorate of Enforcement, in this case, Delhi High Court held that the legislature thus choose to place embargo upon the continuation of criminal proceedings, including the action of attachment under the PMLA. So when Delhi High Court is interpreting the legislation, that is IBC, they went to the basic purpose legislation. The basic purpose of the legislation, why the legislation was enacted. Okay, and the High Court, Delhi High Court, is of the opinion that when the legislature is making the legislation, that is Section 14, they know that there is another legislation, that is PMLA Act. So So under the PMLA Act, property can be attached. They are well aware of that. So even after knowing that under PMLA Act, the directorate, the authorities, Directorate of Enforcement, the authorities, they can attach the property, but Section 14 specifically provides that you cannot attach any property, alienate, transfer. You cannot attach any property of the corporator. So when the legislation knows that there is another legislation is there where you can attach the property, now under this IBC you are saying that you cannot attach any property. So they are well aware of other legislation. So that's why the Delhi High Court held that the legislation intention is that Section 14 must be implemented even in case of Money Laundering Act. So accordingly, Delhi High Court held that so Section 14 can be enforced. Okay, so but if you there are so many judgments are there on this issue. There are so many judgments are there. Okay, Delhi High Court, Calcutta High Court, so many NCLATs gave various judgments in different. They have expressed different opinions. Okay, so we are having contrary views. Okay. But by looking at all these judgments, okay, so many judgments are there. By looking at all these judgments, we can understand that prior to the approval of the resolution plan, the pendency of the moratorium is not a bar. Okay, so prior to the approval, okay, so prior to the approval of the resolution plan, the pendency of moratorium is not a bar. Okay, so that is what we can understand from these judgments. Okay, now let us discuss another concept: power of contempt. Now the question mark is that under Section 14, when you are implementing the moratorium or when the moratorium came into enforcement, whether the court can give the order for contempt of court against the company. Why? Because whenever if you fail to follow the court orders, court generally will give the order for contempt of court. Then against whom the contempt of court order is given, they are liable. Now, can you create the liability like this? Okay, so in the case of Ved Prakash Abbott versus Kishore K. Avarsekar. So in this case, Delhi High Court held that power of contempt is a constitutional power. So because under the Constitution of India, the High Courts and Supreme Court, okay, they are having power to punish any person for the contempt of court. So that is constitutional right. So that's why the constitutional rights, as already we have discussed previously in the previous class. So the next concept, whether court is having power to punish under the constitutional provisions. Under the Constitution of India, High Court and the Supreme Court both are having power to punish any person for the contempt of court. If they fail to follow orders given by the court, then in such cases, High Court and the Supreme Court under the Constitution of India, they are having power to punish any person for the contempt of court. Now the question mark is that when moratorium is implemented or when Section 14 came into enforcement, whether High Court can give the punish or can punish the CD or not, there is a question mark. So in the case of Ved Prakash Abbott versus Kishore K. Avarsekar, the Delhi High Court held that power of contempt is a constitutional power. So as already we have discussed previously, okay, so constitutional powers are not barred. Okay, constitutional rights and constitutional powers, they are not barred by the moratorium. So that's why it is not barred by the declaration of moratorium. So court can always give the order for contempt of court. Okay, so whether set off an adjustment of monies for pre-CIRP dues during the moratorium is barred or not. So before CIRP, some adjustments are there. So during the moratorium, can you do such adjustments or set off? Is it possible or not? There is a question mark. So in the case of State Bank of India versus Debashish Nanda, NCLAT held that bank cannot set off or adjust the amount from CD account during the moratorium period. So though as per the law, bank is having the general lien. Okay, so banking company can have the general lien. So we are going to discuss under this concept is discussed under the contract clause. Okay, so banking company can have a general lien on the bank account. But when moratorium is there, during the moratorium period, bank cannot set off or adjust amount from the bank account. Okay, so from the CD account they cannot adjust. So set off and adjustment of money that belongs to the pre-CRP cannot be adjusted during the moratorium period. That is bad. Okay, whether can you encash the check? Suppose take the example, CD corporate debtor, they have given the check to other person, some opposite person, third party. So whether the third party can encash, because when you are encashing, it means that you are creating the liability. Okay, so you are withdrawing the money, whereby corporate debtor is paying the money. That is the basic meaning of encashing the check. Whether can you encash the check or not? Okay, no, you cannot encash the check. Okay, so in the case of Sri Equipment Finance Limited versus Amit Gupta, NCLAT held that post-dated checks cannot be encashed during the moratorium period. So possibility is there. The corporate debtor, they have already given one check, that is post-dated check formerly. Now the customer or the finance or any creditor, they wanted to encash it. So is it possible? No. Even though it is post-dated, it is not possible to encash the check. Okay. So it was held in the case of Sri Equipment Finance Limited versus Amit Gupta. Another question mark. This is there under the section itself. Essential services cannot be terminated. So if you observe what is considered to be essential services. Okay. So if you observe regulation 32 of IBBA, Insolvency Resolution Process for Corporate Persons Regulations 2016. Okay, the following are considered to be essential services: electricity, water, telecommunication services, information technology services. Okay, so these four are considered to be essential services. And please remember, to the extent these are not a direct input to the output produced or supplied by the corporate. That means if I am using this electricity, water, telecommunication to manufacture or to render the services. Okay, so if it is an input, okay, I am using the electricity as an input to do the manufacturing process, then okay, so it is not considered to be essential services. Okay, so for the going concern, okay, so for the human consumption, okay, so if electricity, water, telecommunication services, information technology services are provided, then these are all considered to be essential services. And please remember, okay, the expenses for these services shall be included in the resolution cost. Okay, so but if these things are used, electricity, water, etc., these things are used, okay, as a direct input to the output produced or supplied by the corporate, then in such cases that is not considered. Okay, then in the case of ICICI Bank Limited versus Innovative Industries Limited, NCLT held that electricity, water, etc. are considered to be essential as long as these services are not requirement of the output produced or supplied by the CD. So when it is considered to be essential, the electricity and water, it is considered to be essential as long as these electricity or water, they are not used as a requirement to the output. Okay, I am not using any manufacturing activity. Okay, so for the regular day-to-day activities, for the essential human existence. Okay, so for the human existence, if I am using, then in such cases electricity, water, etc., they are all considered to be essential services. Okay, so in another case law, RP of Perfect Color Digital Prints Private Limited versus Dakshin Haryana Bijli Vitran Nigam. So in this case law, NCLAT held that electricity is essential. Okay, and whenever you are giving electricity to the corporate debtor, okay, the cost to be included in the resolution cost, as already I told you. Okay, so the amount that is spent on essentials, that is electricity, water, telecommunication, etc., okay, these costs must be included in the resolution cost. So moratorium in another case law, Dakshin Gujarat VIJ Company Limited versus ABG Shipyard Limited. So in this case law, NCLAT held that moratorium itself does not prohibit any payments to the suppliers of essential. Okay, it accounted to the resolution cost. So please remember, so when moratorium is there, so as already we have discussed, essentials are exception to that. Generally you cannot make any payment. Okay, but essentials are exception to that. So what we are going to do, we may not pay immediately, but it is accounted to the resolution cost. Then subsequently, when the resolution process is completed, first we are going to make the payment to the result. So as already we are going to discuss in the subsequent lessons about the waterfall mechanism. Okay, in the waterfall mechanism, first we are supposed to pay to the resolution cost. Okay, so these essentials are accounted to the resolution cost. Okay, now what are all the transactions which are exempted from the moratorium? Section 14 subsection 3 speaks about the transactions. Okay, so such transactions, agreements or other arrangements as may be notified by the central government in consultation with any financial sector regulator or other authority, any other authority. Though under section 14 subsection 3, central government is having power to notify such transactions, agreements as exempted. Okay, so under subsection under clause 3, okay, a surety in a contract of guarantee of to a corporate debtor. Okay, so if any individual is there who is surety to the corporate debtor, okay, then to against them moratorium is not applicable. You can always exercise, okay, a right against the surety. So this transaction is exempted, specifically exempted under the legislation. Okay, then let us discuss some other sections which are relevant. Okay, so in case of moratorium, section 31 subsection 3, so which provides that after the order of approval under subsection 1, the moratorium order passed by the adjudicating authority under section 14 shall cease to have the effect. So as already we have discussed section 31 and 33. So under section 31, once the resolution process, the resolution plan is approved, then adjudicating authority will approve the resolution plan, because it has to be approved by the COC, and once it is approved by the COC, it is going to be placed before the adjudicating authority. In the subsequent lessons, we are going to discuss the procedure. Okay, so the adjudicating authority, once if he gives approval to the resolution plan, then automatically the moratorium that is given under section shall cease to have the effect. That is, on that day moratorium is lapsed, it is expired. Okay, so the moratorium ceases as soon as the resolution plan is approved by the adjudicating authority. So this is section 31. Then another section, section 74. So section 74 speaks about the punishment. Okay, so section 74 states that punishment for contravention of moratorium or resolution plan. Okay, where the corporate debtor or any of its officers violates the provision of section 14. So as already till now we have discussed, section 14 provides for moratorium. So during the moratorium, you are not supposed to transact anything. As a corporate debtor, officers of the corporate debtor, you are not supposed to do any transactions. If any officer violates the provisions of section 14, any such officer who knowingly or willfully committed or authorized or permitted such contravention shall be punishable with imprisonment. Okay, so there is a punishment is there, okay, which shall not be less than 3 years and which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees but which may extend to 3 lakh rupees. Okay, so now when you are violating section 14 as an officer of the company, you are also punishable. Okay, so that is provided under section 74. Then it further provides that where any creditor, okay, so it is speaking about the creditor now, where any creditor violates the provisions of section 14, any person who knowingly and willfully authorizes, permitted such contravention by the creditor shall be punishable. So any person who is authorizing the creditor to do so and so, okay, which is violation of section 14, then such person shall be liable for imprisonment which shall not be less than 1 year and which may extend to 5 years, and fine which shall not be less than 1 lakh rupees and which may extend to 1 crore rupees. Okay, so imprisonment can be 1 year to 5 years and penalty can be 1 lakh to 1 crore rupees. Okay, or with both. Okay, both are possible. Okay, so possibility is there. Adjudicating authority may may give the imprisonment, as well as they can impose the penalty also. Okay, depending on the circumstances. Then another subsection, section 74 only, another subsection, where the corporate debtor, any of its officer or creditors, or any person on whom the approved resolution plan is binding under section 31. So as already we have discussed, section 31 resolution plan is under section 31, resolution plan is approved by the NCLT. Okay, so where the corporate debtor or any of its officer or creditors or any person on whom the resolution plan is binding under section 31, then they are knowingly and willfully contravenes any of the provisions of the terms of the resolution plan or abate such contravention, such corporate debtor, officer, creditor or person. Okay, so maybe corporate debtor or officer or creditor, any other person whoever is abating or whoever is contravening the provisions. Okay, they are liable to pay the penalty. First, imprisonment not less than 1 year, which may extend to 5 years, and penalty 1 lakh rupees, which may extend to 1 crore rupees. Okay, so here on the corporate debtor and officers or creditors of the company, we are imposing the penalty. Okay, so you can understand, okay, the imposition of the moratorium is to be considered serious enough to warrant punishment if not followed. Okay, so you can understand from section 74 that, okay, so this is section 74, you can understand that if you fail to follow the moratorium, okay, so it is considered to be very serious, where there is a punishment can also be imposed on the persons who are violating moratorium. Okay, so let us discuss what we have discussed. Okay, let us recap what we have discussed till now. Okay, so in these classes, okay, we have discussed what is moratorium. Okay, then subsequently we have discussed when the moratorium is applicable, as already we have discussed under section 14. Okay, so when the CIRP process started, that is when the application made by the financial creditor, operational creditor or corporate debtor is admitted by the NCLT, then moratorium will be applicable. So here we have discussed what is the meaning of moratorium, etc., etc. Okay, then subsequently we have discussed transactions where moratorium is not applicable. We have discussed when moratorium is applicable, even we have discussed where the moratorium is not applicable. Okay, then subsequently we have discussed punishment in case of non-compliances. Okay, so under section 74 we have discussed whenever there is a moratorium is there, if any creditor, company, etc., etc., officers of the company, if they violate, then imprisonment is there as well as penalty is there. Okay, so in these lessons we have discussed what is moratorium, when moratorium is applicable, and the transactions where moratorium is not applicable, punishment in case of non-compliances. Thank you.